You want to learn 3 different ways, 3 ways in which an attorney can screw up cross-examination? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, the very first way an attorney can screw up cross-examination is by failing to ask short, leading questions. Now, that is the first cardinal rule that we learn as attorneys in law school. And now when we try cases, we are told, ask short, leading questions. Now, you should know when we bring a lawsuit, let's say for medical malpractice, you believe your doctor screwed up and caused you significant harm and injury. When your case gets all the way to trial, and now we have an opportunity to question our witnesses, we ask our witnesses who are supporting our case open-ended questions. Questions like who, what, where, when, how, why. Please explain, please tell us. We want our witnesses to go ahead and explain as much as possible. And now on cross-examination, when I ask the witness questions, I only want him to be able to answer yes, no, I don't know, or I can't answer the question. That's it. I want to be able to tell the jury a story in my own words and simply get the witness to agree or disagree. So, an attorney can screw up cross-examination by instead saying, hey, Dr. Jones, tell us why you did that. Why? Because now the doctor on the witness stand takes control. And as an attorney who is cross-examining a witness, you never, ever want to allow the witness to be able to take control. The second way an attorney can screw up cross-examination is by not listening to the answers to his questions. There's so many attorneys who focus on what's going on 2 steps ahead. Oh, I know I have to ask this question, then they look at their notes like, oh yeah, I have to ask these other questions, but they're not paying attention to the answer that the witness just gave. And if they were listening carefully, they would have picked up on something, and now they would have followed up with additional questions. So that's another clear way, a second way, in which an attorney can screw up cross-examination. You want to know a third way? A third way is to get into a fight with the witness about how the question is worded. Now, what do I mean? Dr. Jones, I want you to assume that the following facts are true. Assuming that those facts are true, would you agree that failing to do A, B, and C would be a violation from the standard of care? And now, Dr. Jones, instead of saying yes or no, what does he do? He now begins arguing with me. Well, I don't necessarily agree with those set of facts, counselor. Doctor, I didn't ask you whether you agreed with those sets of facts. I simply asked you to assume that those facts are true. Okay, can you do that? No, I can't do that. Doctor, and then we get into a word game, and now we begin fighting over the wording of a particular question. An attorney can screw up cross-examination big time because you lose your momentum and you lose the ability to control the witness the moment you start fighting and arguing about semantics, about the specific words in the question. Here's another example. Doctor, would you agree that it's important for a physician caring for a patient to keep accurate notes? Well, it depends on how you define accurate. Doctor, I didn't ask you to define the word accurate. I simply said it's good medical practice to keep accurate records. Would you agree? It calls for either yes or no. But now the doctor's playing word games. Doctor, would you agree it's important for you to keep thorough and detailed notes? Well, it all depends on what you mean by detailed and thorough. So now you're getting into a pissing match where now the doctor is arguing over 1 word, 2 words, and now you're fighting with him. And how does that look to the jury? I'll tell you how it looks to the jury. It looks petty. It looks ridiculous because now you spend all this effort and energy arguing with the doctor over something so simple. Oftentimes, sometimes it's important, sometimes the wording is extremely important, but for the most part, when now you're getting into a contest with the doctor, it quickly escalates, tensions rise, yelling starts, and now if you get overly aggressive, you run the risk of offending the jury because now it looks like I'm beating up on the witness. So even though the witness may be less than truthful, even though the witness may be arguing as a strategy to try and throw me off track, the bottom line is, if I'm overly aggressive to a particular witness and it's not justified, the jury's going to hold it against me and possibly my client. So why do I share these 3 basic ways that an attorney can screw up cross-examination? I'll tell you why. Because it happens all the time. You walk into any courtroom in New York and you sit down and watch a trial, and you will see attorneys conducting cross-examinations, and sometimes, just sometimes, they screw it up the way I've just described. And if you sit in these cases long enough and learn and listen, you will find even more ways that cross-examination gets screwed up. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding. into what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I do understand you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need answers, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.